CBSN New York.
Joining me now to talk about the judge's decision in Queens to delay the sentencing for Chanel Lewis is Cheryl Bader. She is a former U.S. attorney, assistant U.S. attorney in the District of New Jersey, as well as a current professor of criminal law at Fordham University. Thank you for being here today.
It's great to be here.
So this was a shock to a lot of people. Let's just talk about what happened today.
So the judge decided to postpone the sentencing. The defense attorneys have made a motion alleging that there was some juror misconduct in the deliberation process and are seeking a hearing to determine if they will be able to get a mistrial because of that misconduct.
Let's talk about misconduct. We don't know exactly what happened because Judge Michael Aloise, I think is how you say his name, the justice is keeping that information sealed. But could you fill us in on what misconduct could be among jurors?
So the jury deliberation process is a secretive process, and therefore you're not going to learn what the misconduct was. Even when the judge holds a hearing, the judge is going to do that by, finding out from defense attorneys what evidence they have about this, and then, possibly going forward and interviewing jurors. So there's lots of ways that there can be misconduct. So one might be jurors go out and try to investigate the case themselves, try to go to the scene or speak to people who know about the case, or even just learning information through looking at the media, which the judge instructs them not to do. Other types of misconduct may be trying to assert undue influence on other members of the jury, trying to assert that they know facts that other jurors don't know, etc.
For instance, we do know that we have learned that a couple of the jurors did not believe that Lewis was guilty of sex abuse when he was convicted. And so is it misconduct if they try then to convince the other jurors about their feelings on those charges?
No, that's not misconduct, right? That's what the jury system is all about. It's about, putting 12 people in a room, and as, 12 angry people in a room, right? You're allowed to have emotion and allowed to really sort of, kind of when I say duke it out, right? Obviously there are lines. But arguing and trying to convince other people about the evidence is not juror misconduct. Now, I think in this case, if I recall, the jurors had asked for to re-see the tape of the confession, and that was very important evidence because the defense is claiming that the confession was coerced, and there were some technical problems, and therefore there was a delay. And then a note comes out, never mind, we don't need to see that. And so, again, this would just be speculation, but, perhaps they were disagreeing about whether they should spend the time and wait to see that video evidence. And maybe the allegations are that those jurors that wanted to see that tape felt bullied into not being able to wait that out.